Solvency and Bankruptcy Code has proven to be a powerful tool with respect to empowering creditors to recover their money from defaulters and has boosted India's rankings in terms of ease of doing business. On the 5th episode of the Kotak Mahindra Bank Presents Corporate Conversations powered by Times Network series, a panel of subject matter experts shared their insights on the nuances of India's Insolvency and Bankruptcy Code and the changing face of corporate India.
Hello and welcome to Kotak Mahindra Bank Presents Corporate Conversations powered by the Times Network. I'm Abha Bakaya and today we have an incredibly high-powered panel with us to discuss IBC, the impact and the changing face of corporate India. Abhizar Devanji from E&Y, Cyril Shroff from Cyril Amarchand Mangaldas, and Ishwar Kara from Kotak. Let me kickstart this by asking you, Mr. Shroff, on the impact that the IBC has had on the way corporate India is now behaving, is making decisions on the overall industry, and it's and how it's really evolving and changing now in the context of these new regulations.
First, we must remember that the IBC is not just an incremental change; it's a structural change that has happened in the legal landscape and the policy landscape in India, and therefore its impact is more profound. It's now sort of 2.5, 3 years since the IBC has effectively become operational, and I think we are seeing a number of major themes emerging already. First, I think, has been the impact on credit behavior, and in terms of how both the borrowing community as well as the lending community have changed their approach. I think the borrowers are far more careful in terms of their approach to credit. I think they've realized that debt is something which can be poisonous. You could lose your company, and in the process that leads to the sort of loss of the company, you may not be able to even play in the game thanks to things like 29A. So it's something which is quite life-changing in terms of its potential implications. On the creditor side, again, given the accumulation of the non-performing loans, and again how the entire resolution framework through the various forms has evolved, I think there's far more diligence as well as circumspection in terms of how the banks and other credit providers are approaching. So this is one line of change. The other big impact, I think, has been in terms of approach to M&A. Because of the way IBC is evolving, and a number of resolutions are actually resulting in sales of assets, I think there's a whole new M&A game that has emerged, which is very different from solvent M&A or ordinary course M&A, if I can call it that. So that's another mega change that we've seen coming out of this. The third is in terms of, again, promoter behavior, sort of links up with the first point as well. For example, something like personal guarantees, which was the norm earlier, and now you don't see that as a very sort of popular way of credit enhancing your financing proposal. So I think, coming back to the first theme, I think there have been structural and very fundamental changes that have happened in the financial and corporate markets. The face of corporate India is looking very different. A number of business houses which were sort of in the top 30, 40 companies in India are off that list. I think there is an enormous churn in the pecking order of corporate India. And I don't think we're even fully through that process. I think we're roughly halfway through that process, and there is a lot more to come.
Abhizar, let me get your views as well in terms of, and also both the positives and the negatives. I know it's different, but how would you define different?
Let's talk about the positive and negatives. See, the positives is that now there is a conscious differentiation between debt and equity. Earlier, frankly, equity was available at the cost of debt. And I think that has changed very, very significantly. And I say equity because one is it was literally perpetual. And two, it was backed by personal guarantees, as Cyril just shared. So at the end of the day, I think we are now differentiating between debt and equity. The negative, the biggest negative that we had is that while we have been moving at a very, very fast pace on the law, implementing it also pretty fast, making changes to the law very fast, but we are, I think, only a quarter of the way in terms of changing behavior. And that's a very, very big issue that we have today. And what I mean by that is that the constituents that actually run this whole process, whether it is within IBC or outside, ability of our creditors to really understand the situation that they are in is not there as yet. Their ability to deal with sophisticated financial investors who are now coming into the game is not there. The financial investors, sophisticated financial investors, their ability to understand the constraints of the Indian banking system is not there. And the promoters' ability to let go of their businesses is not there. So we're still dealing with all stakeholders who haven't really come up to a realization that there is a change which is so significant. And that causes disruptions. Look at the level of litigation that we have. Look at the bid-offer spreads that we're dealing with. But what is changing? What is changing is the face of corporate governance. So what's going on now really is when a promoter is replaced by a better promoter or by an institutional investor, then the face of governance changes almost completely. And that, and I do believe that, people like our firm and other people, we kind of propose governance mechanisms. Sure. But only when shareholding goes into the right hands does real governance happen. And I think that is the big fundamental change that we're going to see in Indian corporates going forward. And I think the flow of credit will only now go to those people who are credible. So India lacked 2 C's, in my opinion, capital and counterparty. Now I think we will have the right counterparties with the right capital.
Okay, Ishwar, so talk to us a little bit about, the kind of changes we've seen to the IBC as we just discussed, quick reflexes, amendments, trying to make it more, more adept at solving some of these cases quickly and reaching a resolution. What are you making of some of these changes, the timelines that are being suggested, and will they be implemented? Are they actually going to speed up things?
Now, fundamentally, I think one major change that the IBC has brought about is to the operational creditors. I think prior to the IBC being in force, the operational creditors as a class were never able to recover their money except for filing probably a money suit, and they had no legal system to recover their monies. This law has empowered them that yes, there is hope for them to recover their monies as well. And I think everywhere, wherever the IBC has been implemented, it has evolved over a period of time. And amendments, I must say, it's heartening to note that as and when we are facing some complications in various judgments which have been coming out, the government has stepped in and made these amendments in a very, very swift manner, which is very heartening to note. On timelines, we have been seeing that though there was a 270-day period, that even to get your case admitted, it was taking probably 6 to 8 months. And now that the timeline of 330 days has been put in, I am very hopeful and confident that there would be speedier recovery process, and investors obviously look at these kind of timelines and they are heartened to note of what the government is actually taking steps in this process. Not only that, they have also brought in certain amendments with respect to how certain class of creditors, like the homeowners, would vote. And they have now distinguished them from financial creditors. And these amendments are again very heartening to note. And there's a third amendment which was very critical, which is giving the powers to the COC to take any financial decision. So these are very welcome changes.
Coming back to the changing face of corporate India, Mr. Shroff, and I think we went back when we were just having a discussion pre the panel to where perhaps some of these changes started to kick in. We were talking about the previous RBI governor and the issue of personal guarantees, and really where perhaps you could go back and pinpoint where the system started to feel that okay, the ground is shifting now beneath us. Just talk to us about the phases that have played out, the significant, timelines as you see it, and how they've impacted, behavioral change.
So it's been a series of steps. I mean, it's not fair to say that there was one kind of eureka moment when this happened. I think it started first with the legislation of IBC. Then I think the amendment of the Banking Regulation Act, which gave RBI the power to give directions. Different matter that later on there was litigation about it. Then the referral of the first 12 cases or the dirty dozen cases by RBI giving a nudge to the banks to ask them to go into the IBC process and announcing the list of the next 27, I think. So I think these were some of the key steps. Then subsequently thereafter there were sort of events which arose out of specific cases but caused amendment. For example, the inaction of 29A. Then the more recent amendment which changed the 270 to 330 days. So it's been a series of steps, and I must say apart from executive and legislative proactiveness, I think we've seen an incredibly supportive role from the Supreme Court as well. I can't think of any economic legislation since independence where the Supreme Court has in such a short period of time delivered landmark judgments, starting with the innovative case, then Swiss Ribbon, then there's a whole lot of other ones as well, which in such a fast period of time has kind of settled the law on some important issues. And for a new legislation to come in like this, unless there is judicial support, and at the highest level like the Supreme Court, you can't really take off a regime like this. So everybody has contributed to the so-called sort of success of the IBC, and I think overall it has been a success. I think there are imperfections, but I would sort of give it a 7 on 10 in terms of where we are today. And it's been contributed by the legislature, by the executive, by the judiciary, and all by market participants as well. I think it's been a great collective effort. Yes, it's been a bit chunky at times, but so what?
Abhisar, I want to bring up the SR Steel case. We don't have to get into it in detail, but as sort of the signature event as such that the market looks at in terms of takeaways as to how some of the amendments have played out, what the changes need to be, how this can be applied to future cases.
If you look at the SR case, and there's another case, the Binani case, and like this, there is some similarity between the two and some differences between the two. In the Binani case, what happened is somebody else came and bid. I won't take names. Somebody came and bid for the company first. Somebody else came and topped up the bid later on. And the court said, no, we will go for value. And the person who topped up the bid actually got the bid. And that was a decision taken, well thought through, maximization of creditor value, fair enough. Court took the decision, Supreme Court took the decision, it was fair. Deal happened. The same thing played out with similar facts in the SR case, but was not accepted. And why was it not accepted? Because of the circumstantial evidence that one saw. And when the court, so what I'm trying to point out is that in the SR case also there was something similar. SR came and bid a particular amount. The competitor bid a higher amount. Then both parties ended up upping up their bids in some stage. Yeah. And then we had a SR come and say, I'll pay the whole amount. But that got rejected. One in the same Binani case that got accepted. And the reason is you go back and this is the I would say the proactiveness or the shrewd or the wittiness of the courts. Yeah. That the court actually went back and said, look at it circumstantially, boss. You've been playing around with the system all the way through, and this is something that one will not allow. I'm only talking about things that are in public domain. But the reality is that we're trying to say that if it is circumstantially different, the courts and everybody have supported the spirit of the law. And that, I think, is very important in the SR case. And people have tried to play around with it. Yes, it's taken time. A lot of investors thought they'd made a lot of money, and then they're now saying that they're making lesser money than what they thought, but that's fine. The system has grown very significantly as far as the SR case is concerned.
Okay.
Like we say in Hindi, bhavana. I think intent is very critical over here. And I think the courts are seeing through that intent.
What about opportunities that are created as well, Ishwar? On the back of some of these changes that we've talked about, when it comes to M&A, consolidation, from your perspective, what are you seeing?
So I manage the fund. From the fund's perspective, while we are addressing situations in the IBC as well as pre-IBC cases as well, and thanks to the latest RBI guidelines, we see a lot of cases which are now coming in. So I'm swamped with a lot of proposals, let me say that. But the biggest opportunity which is coming presently is what we are calling a special situations, which is caused due to the NBFC crisis, if you may say. And that has led us to various opportunities. And this has come in three various fashions. One is where NBFCs were usually, in the past, catering to that segment, that is structured credit. Now this structured credit opportunity is coming to all the fund houses. So we are looking at that aggressively. The second is where they have already lent, but they want to exit because they're having their own liquidity challenges. So we are addressing that as well to give it the existing exposures, existing NBFCs, an exit. And the third biggest opportunity which is coming is where they have lent, especially in real estate, and the projects are stuck. So we are giving what we call as last mile funding. So that's the third avenue that we are looking at.
Okay. Do you feel at any level, Mr. Shroff, that perhaps the correction has gone too far, if we were to put it like that? Do you think there's an overcorrection, so as to say?
So a couple of points. I'd like to step back and just look at some of the behavioral changes that have happened as a result of everything. And I think the first point I'd like to make is that IBC is not just one of the things that has happened in isolation. There has been a lot happening even outside the IBC. For example, there is a brand new conversation about corporate governance. I think there have been a lot of significant reforms on governance for publicly listed companies. In fact, Mr. Kotak was the chair of that committee. I think that's one. Secondly, just in terms of the attitude towards enforcement in India. So if you sort of look back, say maybe more than a decade ago, I think one of the most important things was that we have great laws, but they were never enforced. I think one sea change that we have seen, particularly in recent times, is that laws are actually enforced, and they're enforced quite vigorously. So it's a bit of a perfect storm that is taking place, where something like IBC, changes in corporate governance, changes in the Corporate Law Companies Act itself, the enforcement framework, and I think all of that has contributed to what I would call a movement away from a relationship-based society to a rule-based society. I think corporate governance has also changed forever. I think there's a far greater consciousness on related party contracts, the interests of other stakeholders, one of which is debt providers as well. Whereas earlier it was always only about profitability and return to the investor, only one stakeholder, and the others were kind of subordinated, their interests were subordinated. The conversation, because of all of this put together, has moved away from a shareholder model of governance to a more stakeholder model of governance, with a much broader set of stakeholders whose interests are being sort of taken note of.
If I think back, let's say, pick up a Satyam, right? Probably one of the first times that corporate governance became so headlineable and such a big issue. We probably didn't see the kind of change, we saw changes, but maybe not the kind of call for change that we're seeing today, where there's so much more focus and sensitivity around these issues. Would you agree, Abhizar? I mean, I'm trying to get a sense of how much further we have to go.
So, yeah. So Satyam, by the way, was an isolated incident. This is more systemic. And that's the reason why you're seeing such a sea change. Satyam was a financial fraud, maybe, but not a breakdown of a system in that sense. Now, if you, in India, for example, this thing was brewing for some time. So this is a small story, but 2008, when the world crashed, credit in India grew at 26% per annum for 4 years continuously. So we were still building that bubble up. And we thought we were decoupled with the global economy, which we were not, clearly. And that fell out in 2014-15, really. It manifested because that bubble kept growing because we kept financing debt with further debt. And when there was a slam down, that slam down came out too hard on us. What's happening today is that the world economy is again dipping. And this time we dip with it. And that's what accentuates a crisis even further. So this is where we are today. So today we are in a slightly difficult situation that possibly we were at the time of Satyam. So it's more endemic, yes.
Mr. Shroff, I know you said this also has huge ramifications for entrepreneurs today. Any message you'd like to leave us with, for them?
Yes. The good thing about any insolvency or resolution system is that it allows business failure without necessarily having personal consequences or without necessarily an imputation of fraud or wrongdoing. I think one of the challenges that we are facing today is that in several instances, business failure is being criminalized, as a result of which entrepreneurs are going into a shell. And the moment you sort of kill entrepreneurship at that deeply psychological level, you stop innovation as well. And if you stop innovation, I think eventually in the long run, the country is not competitive. So I think whilst a good, quick insolvency resolution framework is a good thing, I think we have to carefully balance it so that it doesn't swing too much to one extreme, and to ensure that business failure and resolution of that situation can be swift and quick, and it does not necessarily touch the business confidence or the self-esteem of the entrepreneur, or equated in all cases with criminality. I think this is where the system has gone too far, and I think it needs, I hope it will sort of correct, because the long-term implications on the private sector are quite severe.
All right. Ishwar, closing comments from you?
Yeah, I would quite agree that you cannot kill entrepreneurship, and that will be a disaster. We are probably at the fag end of the crisis, and from here on I see that we've cleaned up most of the entire mess in the banking system, and from here on I would think that a little more impetus would be required from the government, and I think the economy will kickstart again.
We hope. Vizir, are you as optimistic?
I'm completely always an optimist. No, but importantly, I think banks. Well, we've spoken about entrepreneurs. Banks should lend. I think that's not happening today. New businesses should be incubated. India needs to do a lot more on the infrastructure side, and that should happen. I think there will be a shift in lending that will come in very quickly. At the SME level, I think NBFCs need to get some kind of money to kickstart the economy, as I said. And banks need to invest much more in newer projects. And for that, frankly, to just rely on government for capital is possibly not the right thing. Banks may need to divest some of their assets into a corporate bond market at some stage. And if that happens, frankly, we'll need investors like the life insurance and the pension funds to actually put in money and provide long-term capital. So if that happens, I think we'll see that sea change in the financial sector happening.
All right. On that note, gentlemen, thank you so much for taking out the time and being here with us today and providing such valuable insight. That's all from us on this edition of Kotak Mahindra Bank's Corporate Conversations.